Hello everyone, welcome to BYJU'S Exam Prep. I'm Nivedita Rajay and today's case law is a very long controversial piece of information. The name is Subhash Desai versus Principal Secretary. Now this dispute has been going on since 2019, but considering that it still holds relevance because there are still some things that are left. The Supreme Court is still giving out judgment. It just came few months back, and that is why I believe that it's important that you study this. It not only concerns what is happening, but it also concerns some very important constitutional aspects, such as the disqualification of ministers, the powers of speaker and the governor when it comes to disqualification. Can the members of legislative assembly be chalked out? Can they be sacked? Is that a thing? That is what this case law deals with. What exactly is floor test? How governor of the state plays, or what role does governor plays in this entire exercise? So that is why it is important, and that is why we are discussing it. Good evening, everyone. How are you all? Hello, hello, hello. Okay, so let's start. Before we start, you should know that we have a comprehensive batch for CLAT 24. We are launching batches for CLAT 24 almost every 15 days or a month. We are on to our batch 5. So if you are still, not able to decide whether or not you need a course, well, let me just cut it short and tell you, you do need it. Okay, there is just so much that a competition entails, and you cannot really do it on your own. One factor will always be untouched, or maybe even more than one, and that is what might hamper your preparation. So this is a comprehensive course, meaning that it does not just cover CLAT, it covers every other non-CLAT competition, Jamia, MHCT, ALET, all the other major universities that students go for while giving a law entrance is something that is covered by this course alone. So right from the beginning, wherein we give you the idea of the course and the syllabus and the exam, everything, to the point where you are preparing, revising day in and day out, constantly getting to solve your doubts, is something that this course provides alone. That is why it is called comprehensive. And if you wish to understand the working and the classes, the kind of classes, how we conduct the classes and everything, you can unlock a 3-day trial period. Just enter your login ID or your number and you can enjoy classes for 3 days. So in 3 days, you would have access to unlimited number of classes and you can really understand where you are. Okay. Now let us start. This is the background of the case. Like we discussed, the name of the case is Subhash Desai versus Principal Secretary. Right, so 21st June 2022 is where the entire charade started happening. Eknath Shinde is a very popular person right now. So he, along with some other MLAs, decided not to attend a meeting that was conducted by the then Chief Minister, Mr. Uddhav Thackeray. Now, Mr. Uddhav Thackeray, along with Nationalist Party Congress or Indian Congress, formed an alliance which is called MVA. And, Mr. Eknath Shinde was one of the members of Legislative Assembly. So he, along with certain number of party members, they went missing, refused to attend any kind of meetings. And that is when Mr. Thackeray decided to remove Mr. Shinde from the post of the legislative party leader. Now, Mr. Shinde said that he has a support of over 40 MLAs, and if he withdraws the support, the Mr. Thackeray's party, the alliance MVA, will lose its majority and the government would collapse. Now, Mr. Thackeray was declared to be someone who did not represent party's ideals, the Shiv Senas, or the basic foundation or the spirituality that Shiv Sena once stood for. Mr. Thackeray, Mr. Uddhav Thackeray, deviates from it. He does not share the same ideology, all those things. And Mr. Eknath Shinde actually had a tussle with regard to that particular ideology. Our ideologies do not match. You believe something else. I believe in what your father used to believe. So we definitely cannot allow you to represent us as a leader. Now that was the political tussle. That was the means of or the reason of dispute. 24 June 2022, Mr. Thackeray urged the Deputy Speaker to begin disqualification proceedings against Mr. Eknath Shinde and all the other rebel MLAs who decided not to support Mr. Thackeray. And Mr. Shinde challenged those proceedings in the Supreme Court. Now, this is where we get a little bit off the topic. Supreme Court generally does not interfere in party politics. Okay, that is the ideal scenario. Judiciary, executive, legislature all need to remain separate. And unless, all those questions are to be decided by the speaker or the deputy speaker, all the disputes relating to the party need to be resolved by the party. And the courts do not interfere in it. But the Supreme Court did interfere in it. The Supreme Court did hold something. It came out with a judgment which was very unexpected, something that that doesn't happen usually, and that is why this case becomes important. Now we have the powers of the Supreme Court in relation to disqualifications of members from Legislative Assembly. Can Supreme Court also interfere in disputes relating to MPs, member of parliaments? अगर कोई मेंबर ऑफ पार्लियामेंट या एमएलए डिस्क्वालिफिकेशन प्रोसीडिंग्स फेस कर रहा है या फिर उसे निकाल दिया गया है और ये पूरा का पूरा जो डिस्क्वालिफिकेशन डिसमिसल का जो पूरा प्रोसेस है वो स्पीकर और पार्टी के अग्रीमेंट से हुआ है, तो क्या सुप्रीम कोर्ट को यहाँ पे इंटरफेयर करना चाहिए? और अगर सुप्रीम कोर्ट इंटरफेयर कर सकता है, इफ द सुप्रीम कोर्ट कैन इन फैक्ट इंटरफेयर, व्हाट वुड बी द पिटिशन बी? वो किस ग्राउंड पे इंटरफेयर कर सकता है? वी नो कि डिसमिसल जो डिसमिसल होता है या डिस्क्वालिफिकेशन होता है, obviously the final decision rests on the speaker, but then the decision of the speaker is subject to review by the court, right? But this is clearly not review. Comes the review power of the court. Now you have homework. Review power of Supreme Court. जब भी हम न्यूज़पेपर या कुछ भी ऐसा पढ़ते हैं जो कि रेलेवेंट है, जो सुनने को मिल रहा है, एवरीबडी इज टॉकिंग अबाउट इट, तो ज़रूरी नहीं वैसा का वैसा ही कुछ उठा के आपको एग्जाम में दे दिया जाए. नहीं, ऐसा नहीं होता. एक सेगमेंट को, स्पेशली एक पॉलिटिकल डिबेट को जिसमें कॉन्स्टिट्यूशन इन्वॉल्व है, वो मल्टीपल तरह से डिस्कस की जाती है. जैसे इस केस को अकेले फ्लोर टेस्ट और सुप्रीम कोर्ट के पावर के पॉइंट ऑफ व्यू से डिस्कस किया जा सकता है. इस केस को गवर्नर और स्पीकर के पॉइंट ऑफ व्यू से भी डिस्कस किया जा सकता है, और इस अकेले केस को मेंबर्स ऑफ लेजिस्लेटिव असेंबली, सॉरी, of course, my apologies. What I shall repeat everything. Now what am I saying? What I was saying is that whenever there is a case law in picture, whenever there is an information relating to legal perspective in picture, we see that it can be discussed from a numerous point of views. And what is being presented by one magazine or one newspaper does not necessarily mean that that would be in your question paper as well. For example, this case law can be discussed from various aspects, from various point of views. It can be discussed from Supreme Court's powers alone. Does Supreme Court have powers to entertain matters like this? One point of view. Another point of view can be that of speaker and governor. What role and what powers does a speaker and a governor have in this entire process? Then it can be discussed from a constitutional aspect. Disqualification of members. What exactly is floor test? How does a majority matter? What exactly is an alliance? What happens if a party or none of the party is able to gain majority in the house? Now this is a pure constitutional aspect. So this case alone gives multiple point of views. 3 which I told you, there might be other point of views as well, right? So whenever you are reading a segment, whenever you are reading a newspaper, consortium does not just expect you to read what is written. And when you see that child who is trying to lick, something that is on her mouth, especially on Hindu, and it means that you need to eat the newspaper, completely grasp it. So newspaper eating does not really mean that you dissolve it in a glass of water and drink it. No, it means that you read it from all perspectives, all point of views, and that is what we call a wholesome reading, and that is what every competitive exam requires. So when a person is reading or preparing for UPSC or high end competitions like that, they read newspapers this way. And when you are preparing for CLAT, mind you, you need to read newspapers the same way. Okay, so these are some things that uh, are very important when it comes to your competitive preparation, and that is what makes your GK and legal reasoning sound. That is what makes you above the average pedestal. I've always been saying that, a child is on the same pedestal when it comes to GK and legal, because they would grasp the concept in the same manner, they would read from the same sources, they would understand everything in the same manner. So there's no one among the entire lot that is going to take CLAT who is very good in GK or very good in legal. They would more or less be on the same level. But if you do these things, you would have achieved a special significance because you're doing it right. Right? So this is something that I cover in my newspaper classes that are conducted every Friday at 6 p.m. on the BYJU'S Exam Prep portal. This is how we read the newspapers, multiple point of views. Okay. Moving on. 28th June 2022, what happened? The governor of Maharashtra was requested to direct a floor test. Now, what exactly is a floor test? Is something that your homework. That is your homework. Now, you have two homeworks. If I'm giving you a homework, make sure that you do it. Okay, there's a reason why I give you homework. So what exactly is floor test? Floor test basically is a scenario wherein a party is required to prove majority, which means that they still, command support of the members, whether it is parliament or the legislative assembly. So this is what happens. Let's say that there are 500 seats in the parliament Lok Sabha. A party, in order to make a government, has to win 50%, more than 50% of the seats. So if any political party wants to form a government at a central level, they need to have won from more than 50% of the constituencies. And that is what majority is, and that is only when they can form a government. But what if the party is able to secure only 49%? Well, they cannot form a majority government in that case. What happens is the second most winning party, let's say after 49%, there was another party who won 27% of the votes. Right. So these two parties will form an alliance and they would form a government together. That is something that happened in the Maharashtra elections. Uddhav Thackeray Shiv Sena could not win the majority elections, could not prove the majority. So they formed an alliance with the Congress party, MVA. That alliance is called MVA. What is the full form of MVA? Something that you need to figure out on your own. Right. So, till the time you have the majority, you continue to be a part of the majority government. So basically, all the members of the legislative assembly, all the members of the parliaments need to side by you. They need to support you in every matter that is being presented. So if at all there is a bill that is being passed, it cannot go unchallenged. It has to be passed by the majority. If it is not passed by the majority, members of your own party are not favoring your bill, it means that you are losing support, you're losing majority. And as soon as that happens, the government collapses. And floor test is one of the way in which a party needs to prove before the speaker and the governor and the opposition that we still command majority and we still own the government, or we still are part of the government. So as soon as the floor test was ordered, Mr. Thackeray challenged the floor test in the Supreme Court. But the Supreme Court here denied that we are not going to interfere with the floor test. That is something that the executive lays power over. We cannot interfere. And although the Supreme Court also said that, the floor test would be subject to what we also declared. So since the disqualification of the ministers is still impending, we have not really, pondered over that question, the question that was challenged, that you have disqualified them. So since that is also in pendente light, the judgment is pending, and then there is a floor test that is going to happen, both of them would be subject to each other. But Mr. Thackeray refused to participate in the floor test, and before the floor test could happen, he resigned. That is what happened. Thereafter, the Chief Minister Thackeray resigned within an hour, making way for the Shinde faction to consolidate power. Now, the Thackeray faction argued that the actions like disregard for the party whip, appointment of deputy secretary, call for floor test, insistence of Shinde's faction's majority were acts of defection. So, the party that you won from, that is what defection prohibits. The party that gave you candidature, the party that gave you representation to appear from a particular constituency, you need to be faithful to that party. Right? You were a part of a certain banner. You were a part or a face or a representation of a certain party. Now, throughout your tenure, you need to stay faithful to the party. And if at all, in the middle, if you think, no, I don't like this party, I'm going to switch to another party, better everything, then you are committing defection, which is prohibited by the constitution. As soon as you do it, you are disqualified as a member. You lose your candidature, you lose your constituency. Now, what Mr. Shinde did, he did not attend the meetings, the party meetings, the legislative assembly meetings, did not attend anything, stopped supporting the leader, challenged the floor, called for a floor test from the same party. Generally, floor test is being, presented or demanded by the opposition. The opposition wants the majority government to prove their majority. That is how it happens. But Mr. Shinde is from the same party and yet demanding the floor test. Not good. Then he's challenging the appointment of deputy speaker because he thinks that deputy speaker is going to side with Mr. Uddhav Thackeray. So all these, disregard, all this acts of disregard are against the party, and they call for defection because you are really doing what you are not supposed to as per the provisions laid down in the 10th schedule. Meanwhile, Shinde faction approached the election commission, and the party's symbol was given to Shinde as bow and arrow, and the name Shiv Sena was given to their party. So now Shiv Sena has a new leader, Mr. Eknath Shinde, and they have a new, party symbol, which is a bow and an arrow. To use party symbol in the upcoming local polls. 6 September 2022, SC announced that the case would be decided by a 5-judge bench. The same case, the challenge or the question of disqualification that was challenged by Mr. Eknath Shinde. What were the issues under consideration? Whether splitting between or within a political party can be termed as defection. This is a very important question. And if it holds relevance, if it is decided in favor of defection, we would have a whole new interpretation to what would be defection. Or agar is pe judgment aa jata hai, if a judgment comes out on this particular question, mind you, it is going to be in your exam. Whether rebel within a political party amounts to defection. Whether Shinde faction can be subject to disqualification proceedings under the 10th schedule. Whether disqualification of MLAs vests within the power of the speaker. Now, these are the issues that are very important since they hold constitutional relevance. What was held? Governor had no objective material to call for a floor test. Now, this matter is not completely decided. The Supreme Court has not given a wholesome or a complete picture of what would be defection, whether this would be defection, etc. So this is what is held. It's, more like a partial judgment, doesn't really conclude anything, but we shall see what is written. Governor had no objective material to call for a floor test. The speaker would decide whether Eknath Shinde faction had defected from Shiv Sena. So they have, transferred the question to the speaker. He would decide the question of defection. Supreme Court won't. The Supreme Court referred Nabam Rabia versus Deputy Speaker to a larger bench. So a 5-judge bench decision, or this is basically a 5-judge bench decision is being referred to a 7-judge bench. Although the Supreme Court denied that, we won't uh, refer it to the 7th bench. Anyhow, Nabam Rabia or Rabia, a constitution bench of the apex court, held that it is impermissible for a speaker to adjudicate upon disqualification petitioners under the 10th schedule after a notice of intention to move a resolution for the removal of offices issued. This is not held in this Eknath Shinde wala case. It was held in Nabam Rabia case, that once once the leader of the party or once the petitioner has proceeded with a notice that you remove this particular man from the party or you remove him from the post, there is not really a question of defection. The judgment, authored by Chief Justice of India D.Y. Chandrachud, made an interesting observation that the test of legislative majority will be futile in assessing which faction is the real Shiv Sena. Okay. Observation was made while discussing the issue whether the Election Commission of India should defer its decision as to which group is entitled to official party symbol as per the election symbol order till the speaker decides the disqualification proceedings. Also, the fact that Eknath Shinde's party, the new Shiv Sena, has been given the name Shiv Sena, and they have also been given permission to represent the bow and arrow party symbols in the local elections, which is something that should not have been allowed since the party is split. So until and unless the speaker's decision is out, who remains what? Are the members even disqualified? All those questions, until those questions are reserved or resolved completely, the Election Commission need not interfere, governor need not interfere. That is what the crux of the judgment is. Now, before we move to the continuation of Nabam Rabia, you should know that we have a live interactive workshop on 2nd July at 6 p.m. on the BYJU'S Exam Prep portal app. Now, in this workshop, we are going to discuss the time management skills. I understand that the questions have been reduced. Now you are facing, or you only have to do 120 questions as opposed to 150, but there are still some things that remain, because you only have 5 months remaining for your exam. So during these 5 months, if you have started preparing, how do you cover everything within the 5 months? If you have not started preparing at all, the question was, if you haven't started preparing at all, you're going to start from the scratch, how do you start so that 5 months cover everything, the revision, preparation, and all of it, enough practice. If you have started and you're somewhere in the middle, what needs to be done after that? If you have already prepared everything and all you are doing is revision and practicing, how do you need to prepare and revise how do you need to revise and practice so that you can utilize your time better? Now, all of this comes with the parallel that you have boards also after 2-3 months from CLAT. So since you would be focusing on boards also during the month of October, November, how do you manage your practice and your revision during that preparation? So all of that would be discussed on Sunday at 6 p.m. Be there. This is what the Supreme Court has observed. Now you can read it for your own knowledge or your own interest. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on part of some MLAs is not sufficient for a governor to call floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. Right, so the governor allowed floor test based on only some members who were from the same party. So, floor test, like I said, is generally called for by the opposition. When it is being called for from within the same party, then there is a question of majority. Does the government even hold majority? Does Does the government even hold confidence in the house? Does it need to collapse altogether? So in this situation, the governor cannot really use floor test as a means. There are other instruments or other tools that are to be used in order to resolve this dispute. Floor test was not a good idea. These are the key legal questions that are arising out of the case. Like I said, multiple facets of the same case. Role and impartiality of the speaker. Definition of a political party, anti-defection law, the interplay between anti-defection and the freedom of speech, and the governor's role in floor test. Like I said, multiple aspects are covered from one segment. These are the aspects that are relevantly covered. Make sure that you read all of them. We are not discussing them here. This is also your homework. So evidently you have a lot of homework. Do it, and you would have covered Subhash Desai case in a complete wholesome manner. Okay, this is your homework. Make sure that you read all this. Oh, that's it for today. This is about the anti-defection law. The anti-defection law was added in 1985 by way of 52nd Amendment. Aya Ram Gaya Ram was the popular motto at that time. And a new schedule was added to the Constitution. It is called the 10th schedule. I already told you what defection is, and this amendment was introduced so that a political defection or moving from one party to another party can be curbed, because it introduces instability in governance, and the entire foundation of democracy, which is in fact stability, is endangered. The remedy proposed was to disqualify the member of either house of the parliament or the state legislature who was defecting. The constitutional validity was assailed and assailed as in it was upheld in Kohoto Holohan versus Jashilu and others in 1992. So like I told you, workshop, we have a workshop on 2nd of July. Make sure that you're attending it. That's all for today, guys. I hope you learned something from this session. Make sure that you're doing the homework that is being given to you. It is, if you do it, it would be for your own benefit. I'm not getting anything out of it. Your preparation is becoming more wholesome. Make sure that you are attending all these sessions, because you won't be able to cover multiple facets or different point of views from the same segment. But I can tell you the point of views, and you can prepare accordingly. And you're getting to do that for free. So make sure that you are in this class. Right, so thank you so much, everyone. As you can see, please like the session. Do not forget to like the session. Make sure that you subscribe to our channel if you haven't already. You can follow us on Instagram. You can like us on Facebook. You can also join our Telegram channel. And I shall see you again tomorrow. तब तक सब अपना ख्याल रखेंगे. हम कल फिर मिलेंगे. Bye bye. Thank you, guys.